So when I go to court, this is a judge I had, Bruce Ehrman. Lo and behold, Bruce here, I did a video with him in it on YouTube like over 3 months ago. And I didn't realize he's a judge now, but I did notify on Christine Mel's Facebook. She was friends with Bruce here, and as far as I was concerned, or as far as I knew, he was the assistant county attorney in Scott County. And the video I did prior a few months ago with him in it was talking about Mark Mel's wife, which is Christine Mel, and her working in Scott County, and her being friends with, well, the assistant county attorney, which now he's a judge, about how, of course, they're not going to do nothing, and they're not going to look into it or do anything whatsoever about Jeffrey Watney, the registered pedophile that was around my child, and child protections and social services and the probation office did nothing about it, never informed me, contacted me, anything whatsoever. After me digging into it, looking into it, well, of course, recording all the conversations with them, so there was no misunderstanding or he said, she said, or I didn't say this, I didn't say that bullshit, and just cut that shit right out of there. And it was just straight conversation, so there's straight facts, and that's all it is. But so yeah, lo and behold, you know, it festered into more and more and more, and all the way until Dakota County, they're not going to do anything whatsoever, and just we did our job, and he ain't no violation, and fuck off, and here's a letter we're going to send you, and any more correspondence or anything regarding this issue will only be in writing, whether an email or writing a letter and sending it, I guess. Probably due to me recording the conversation and just keeping shit real, you know. And, of course, they won't talk to me on the phone and let me record it anymore, and I wonder why that is. I mean, the only people that do shit like that is like, well, they definitely have shit to hide. And it doesn't matter because I already busted them out and I already fucked them over in their lies and I already proved it all. And still they don't do shit. Now, if they would have done their job or even done anything when I brought it to their attention, shit would not infester into what it is now. So, now this is the judge I had, which I already explained. The video I did on him on YouTube, talking about with him in it months ago. So, I mean, it always baffled me on how something could actually happen where a sex offender was around a minor child. I was never informed. And Scott County, where his charges were originated out of, nothing was ever done. When I went down, contacted with the probation down there, and it was just hee-haw, hee-haw. And after digging, well, here's clearly probably the reason why. That's Mark Mel's wife. Mark Mel is Terry Olson's supervisor. Terry Olson is the probation officer out of Dakota County who oversees Jeff Watney, which is a sex offender. So the sex offender, Jeff Watney, his probation officer is Terry Olson. Terry Olson's supervisor is Mark Mel. Mark Mel's wife is Christine Mel. And here's Christine Mel. She works for Scott County, Quality Improvement Manager. So, wait, there's more. Now, of course, Christine Mel on Facebook is friends with Bruce Ehrman, which is assistant county attorney in Scott County. As you can see, friends with Christine Mel, which is Mark Mel's wife, and Mark Mel is the probation officer supervisor in Dakota County. course, I sent Bruce Shearman a message on Facebook, a messenger. And wow, here I thought you were a Scott County assistant attorney. And to come face to face to you the other day, small world. Or it's a small circle of people that I have to deal with. I still have my messages in Messenger that I have sent you months ago, and I feel all this would be, well, conflict of interest. As months ago I did a video of Mark Mell's wife, and it has you in it as well. I will be posting the court audio from the other day, as well as with my messages on Messenger that were sent to you months ago. I am a father, and I am willing to do anything I have to do, even if it ends my life doing so. Sorry if I was not doing my job as a father and standing up for my rights, then what would that make me? I feel you are a stern judge, and you will be a good judge for the people. Just feel there's too much conflict of interest to put you in my case.
And this is 19 HNCB 222699. Jeffrey Fleming versus Matthew Becker. We have appearances here today by Charles Clays on behalf of Jeffrey Watney. We also have Matthew Becker appearing here today, representing himself pro se. So to the parties, this matter was set on for a motion hearing a request to modify the harassment restraining order that had been previously issued in this case. I would note that back on August 12, 2022, a harassment restraining order was issued in this matter. There was a certificate of unserved process or non-service in this matter, such that a request for an affidavit of service by publication or alternate means was filed back on September 10th, 2022. 2 days later, on September 12th, 2022, Mr. Watney filed a notice of motion in motion to modify the harassment restraining order. That motion was also unable to be served and was ordered for publication by alternate means. On September 26, 2022, an affidavit of publication was filed in this matter indicating that a harassment restraining order had been issued on August 12, 2022. That order for publication and the notice of issuance of a harassment restraining order by publication was published in the Dakota County Tribune on September 23rd, 2022. This matter came back on for hearing on October 12th, 2022. That order was continued as publication had not been completed on the modification motion. The matter was reset for today's date. UC, an affidavit of publication was filed on November 1st, indicating that the notice of motion and motion to modify the harassment restraining order was published on October 21st, 2022, more than 7 days as required to have the hearing today. We do now have an appearance here today by Mr. Becker, who was just served a copy of the original harassment restraining order here in court. Mr. Becker, you have a copy of both the harassment restraining order as well as the notice of motion and motion for modification, correct?
So as he said, the notice by publication, here was one of them. Here's the other one. And here's statute on delivering. If an officer is unable to deliver it, they need to at least mail out a copy of whatever it is, the order or whatever he's filing before they do the publication. So if an officer can't deliver it, no one's there, they have to at least mail a copy to the last known address before doing the publication, which I received something in the mail about the court stuff. Like I told them at court. And I told him I thought it was in regards to the papers Chrissy filed on me. And this letter wasn't in with the papers when they served me at court. And this here, on October 12th, they actually already had a hearing. This is a hearing on him trying to modify it, which was continued. And by them mailing it out, that's how I became aware of the court date. And this says, court administration shall effect service of the motion to modify by publication. So he showed up to court on a date that I never even was aware of the court date, which there was no court date because they never gave me any papers of a court date that they have given him, which was one that he showed up with his attorney, but they continued it. And said they were going to do it by publication, but decided to mail me out something on October 12th about it, which would have made it at least exactly the 20 days that it would have been for me to file on it if I would have been notified about it, if they would have mailed me something. But they mailed out something exactly 20 days to the day that would have been the deadline of the 20 days I would have had to file to have a hearing on the restraining order itself. And like I told him, yeah, an officer was trying to deliver papers, yada, yada, yada. And I told them, I believe it was due to Chrissy. Now, they could have notified me about this court date or about him filing it when I called Dakota County and questioned about me getting a letter in the mail about Chrissy filing it. And here's one that Chrissy filed. Now, they could have notified me about this court date when I called about this court date, which is a YouTube video on that. They didn't say anything about it, about Jeffrey filing a restraining order or modifying, nothing. And petitioner withdrew her motion, like I said. Now, they could have said something when I called on this. They never said nothing about Jeffrey, whatever, filing shit. They could have said something when the police showed up at my house. So it gets some knocking on the door. Some cops show up. So I call on it. So, officer calls me back. So,
Mr. Place, I would know this matter comes under
let's get back to it.
unusual posture as I just laid out before the court. What is your request to proceed here today? Thank you, Your Honor. It is our understanding that the original ex parte order has gone into effect. We are here solely on the motion to modify the language in that original order. And it was our intent just to make oral arguments on that motion here today. And Mr. Becker, you appeared here today after being served by a publication. What is your request as to how to proceed?
I'm here today to order a publication. What do you mean by that?
Are you ready to proceed as to argument as it relates to the petitioner's request for modification?
I'm wondering how you came up with here today due to me being notified of the court date. I was notified of the court date just a couple days ago.
Okay. How did you get notification?
A letter came from the courthouse. It was the 20th or something of the last month, or it was the first of hearing about it was at that point.
Okay. And again, if I laid out history, I'll say the one moment. of non-service from Deputy Shepard, that's Scheppers, indicates that back on August 17th, August 18th, August 20th, August 22nd, he was unable to get any response, indicating he knocked on your door, left notices which were never removed, and call me, left voicemails, and no response. That is why the court previously issued an order for publication after being unable to serve you after multiple attempts to do so. Mr. Becker, did you need a moment to look through that paperwork then and to be prepared to respond to the petitioner's request to modify that here today? How would you like to proceed?
Ready to proceed today.
All right, so after you got notice, you said you got something in the mail from court saying you had to come here, correct?
Correct.
That was on the 20th. Is that correct?
Roughly, I got it. Whatever it was sent out.
Okay, so when you say you want to dispute it,
I don't understand why the county, I never knew where one was in place. Or one was in place for the past 12 months. And going all into the video. I believe the one that was trying to be served was the one that Stephen was trying to serve on me, and I received a letter on that, and a copy of that, and a letter coming back saying that she withdrew whatever it was on the island. And I believe that was the only thing they were trying to contact me about.
I don't know, there's a YouTube video of how many times I called the county attorney's office in between all this, and they never said nothing about it. And the Facebook message between me and Jeff's daughter, she clearly stated why they're all avoiding me and not saying nothing to me was due to all this. They could have informed me at any time about this court date. Instead, they are frivolous about it, didn't bother mailing out nothing, or say anything about it, so it'll all go in effect, where I wouldn't have been aware of it, or any knowledge of it. But mail me something out the day that would have been the exact 20 days it would have took for me to file on it. They mailed me out a letter about him modifying it.
Mr. Becker, when you say you're looking to challenge it, I understand where you're going. The issue is, if you were to challenge it, you were to file a request for a hearing. You never did that because you're saying you never got notice. But yet here we are. You're getting a copy in the mail. Service being done by publication. And we don't have you violate the notice for request to hearing and challenge it. The only thing I have in front of me today is a request from the petitioner to modify the request. So my thought is, if your intent is to challenge it, you need to fill out the paperwork. The judge will have to review it and determine if you're past your timelines for when you were required to do it. As typically, the law says you have 20 days to request a hearing after an order has been granted.
Can I file a court date on papers that I got after the court date already happened? So I filed papers 20 days prior to the court date. Bring the papers on the mail months after that, it was already ordered.
I recognize your concern.
But I would have filed it. The papers that were with police here, it stated that he's trying to modify it, which I never even know if it's in place in the first place. That he's trying to modify it, and that was the court date. That's why I'm here today. But I didn't have to file papers because it was already a court date that was in place. And the papers that were here for me to file a motion to, ask for a court or whatever court date was already once past it. I don't know where anything was even there at all. File something that is once past in order. I mean, that I was even not even aware of.
You keep saying you're not aware of it, yet again, we have a deputy who tried a number of times to call you in, to leave messages, to put things on your door. You're saying you never got those messages.
I believe it was one that Christina filed on me. I have a copy of the letter from Polk County stating that I had a court date with that, and then I got a letter back stating she withdrew her filing on the restraining order. I believe that's what it was called. I have a copy of that letter from the Asian courthouse.
I have no idea who Kristen is, so it's just out of box to try to understand the intricacies of the relationship here.
It was Mr. Wyden's wife.
Okay, we'll figure it out. But again, the deputy left messages on your cell phone. You thought it was about something else, but you didn't call back.
That's what it was about. I already received the letter in the mail about it, and I did call back, and he told me that he sent it back to the court, that there was whatever, every issue with her, whatever, be counted.
Who did you speak to?
And Shepherd.
Alright, here's how we're going to proceed. In your argument today on the modification, I'm going to take everything under advisement, procedural history, and issue of order, conclusion. That's what I mean. But we're not proceeding on the original underlying harassment or restraining order that issue we're performing today. To place then argument as to modification of the harassment or restraining order.
Thank you, Your Honor. Specifically, this request is not necessarily based on new conduct by Mr. Becker, but is instead just being done in order to ensure that the original order has the most specific language to prohibit the conduct that we're most concerned with. The current order is rather general and standard in that it prevents a respondent from having any direct or indirect contact with the petitioner. What we are asking for is that the order be modified to specifically include that the respondent is not to post or do anything either virtually, online, or in person via flyers, or I would even now include via clothing, because I see that Mr. Becker here today in court is wearing a custom sweatshirt that has Mr. Watney's name with the word sex offender included on the back of it, which is being done in order to harass, both posting of YouTube videos, handing out of flyers, and now wearing clothing with my client's name, is all conduct which was occurring at the time the original order was sought. The current wording of the order, though, simply prevents direct or indirect contact. It does not explicitly prevent the continuing posting of these YouTube videos, the handing out of flyers with my client's personal information, or the wearing of this clothing. Specifically, the YouTube videos which we are referring to, a link of which was included in the motion that Mr. Watney filed, not only discuss my client and his previous case, but it uses my client's personal information. It has posting of addresses. It is posting of pictures that include not just my client, but my client's family. And overall, it's just a series of clips of respondent making calls to various Dakota County officials about Mr. Watney, with essentially a slideshow of videos in the back that are specifically using personal info and personal pictures of my client, where the only intent there is to harass. Again, this was all included in the original petition. This isn't necessarily new conduct. It just seems to us that the standard harassment restraining order language of no direct and indirect contact is not sufficient to cover this conduct. Those videos still remain up to this day, and it is our understanding that flyers have continued to have been passed out. And again, we now have this new concern of clothing that respondent is wearing. Thank you.
So where is all this proof about me still handing out flyers or hanging signs or whatnot? Where is that proof? All my text messages, the whole thing is up there on YouTube.
That's one of the issues I was particularly concerned with is essentially this central issue to the court's regulation of speech in particular, in understanding that there's a fine line between what's actual and harassment. And in particular, your request for relief, acts of public humiliation, and pointing out things about Mr. Watney's past and history, and where the court can effectively draw the line in crafting an order not overbroad, that specifically contemplates some sort of differentiation between what is harassment as defined by Minnesota law and what is an individual's